Hi. Good afternoon, everybody. Thank you for joining us for this panel discussion. I'll just quickly take a few minutes to give a little brief introduction of all my esteemed panelists here. We have Justice Uday Umesh Lalit, who is a former Supreme Court judge. He served as the 49th Chief Justice of India. He was one of the 6 senior counsels who were directly elevated to the Supreme Court and the second such person to become the Chief Justice of India. During his tenure as Chief Justice, he brought about major administrative changes and authored various landmark judgments. He is now regularly appointed as an arbitrator in various high-profile matters and also delivers lectures at various prestigious law schools of India, such as the Jindal Global Law School, the National Law Schools, and even the Bombay IIT. Thank you so much, sir, for joining us. We have Mr. Baiju Vasani. He's a barrister and arbitrator with 20 Essex in London. He's an expert in the fields of investor-state disputes, international commercial arbitration, and public international law, with a remarkable career spanning 2 decades in international law firms. Mr. Vasani has represented both states and investors under ICSID and UNCITRAL rules and also played a vital role in advising on investment treaty negotiations and drafting. He has an active pro bono practice and also holds the position of a senior fellow of international law at SOAS, the University of London, where he teaches international arbitration to postgraduates from around the world. We welcome you, Mr. Vasani, and thank you so much for being here. We have Dr. Sanjeev Gemawat, a highly accomplished professional known for his strategic thinking and business acumen, with impressive credentials as a chartered secretary in India and the UK, as well as postgraduate qualifications in the law and doctorate specializing in insider trading. He possesses a diverse skill set. Currently serving as the Group General Counsel for Vedanta Group, he has nearly 3 decades of rich experience across a wide range of industries. His exceptional achievements have earned him prestigious titles, including recognition as one of India's top GCs by renowned publications such as Forbes India and the Business World. We welcome you, sir. Thank you so much. We have Ms. Smarika Singh, who is a partner at Shardul Amarchand's Dispute Resolution and Arbitration team. She focuses on litigation and arbitration matters. She has extensive experience in both domestic and international commercial arbitration, along with related litigation. Her arbitration experience spans across various sectors such as construction, hospitality, shareholder disputes, and across various jurisdictions. She regularly appears before the Supreme Court of India, the Delhi High Court, tribunals, as well as all major institutions across the globe. Thank you, Smarika, for taking out the time and being here. It's indeed an honor for me to be a part of this distinguished panel. Just a brief introduction of the topic today. Our topic is arbitrators' disclosure obligations. When is it enough? Now, disclosure obligations of arbitrators uphold a very fundamental principle of arbitration, which is transparency. The provisions of the Arbitration Act, which require the arbitrator to disclose any circumstance which may give rise to justifiable doubts, was introduced by an amendment in 2015. It also introduced the 5th schedule, which lays down situations which guide the arbitrators to make such disclosures. Now, the extent and impact of these disclosures is what we will be discussing today, and the intent of the session is to give a legal as well as a more practical insight into these obligations. Now, without further ado, let me kickstart this panel. My first question is to Justice Lalit. Sir, what is your opinion on the disclosure requirements under the 5th schedule? Are they wide enough to encompass any situation which may cause such justifiable doubts?
Good afternoon, everybody, and welcome to the session. See, the schedule which got amended and included so many diverse topics has expanded the matter, perhaps I think, way beyond the expectations of anybody. It now includes situations where perhaps not just a shareholder or having an interest in the property, but even communications or even relationship with the counsel in question or the law firm in question can also give rise to, and it must be disclosed clearly. So therefore, to that extent, perhaps I think the requirements of the law after the amendment are more stringent, more wide than what we had before the amendment. I'll just give you 2 outlines, 2 decisions before the amendment. One was by Justice Ravindran in that Indian Oil or something, correct, where The argument was that in fact, it was an ad hoc arbitration, a named arbitrator who was the employee of one of the parties. So therefore, the argument which was canvassed was that there will always be some kind of bias when the arbitrator takes the seat. But that was rejected by the court, saying that, the parties have chosen to go to arbitration before the named arbitrator. Similarly, I had the occasion to deal with a matter prior to amendment, which was Aravali. We also followed the dictum which was laid down by Justice Ravindran and said that if the parties wanted it, even if he happens to be the managing director of one of the parties, the arbitration must be before such named arbitrator. So therefore, this was the scenario. Now look at the situation which is obtaining today. Now today, TRF, which was decision rendered by Justice Deepak Mishra's bench, that a party would not have the freedom to appoint a nominee or nominate an arbitrator, correct? So TRF went to that extent. It can't be the arbitrator himself. We took the matter further in Perkins and said that if the party cannot be the arbitrator, then the party should not even have the right to nominate an arbitrator. So therefore, the kind of detachment, the kind of sort of distance between the party and the arbitrator is now the hallmark of the amendments which have been brought in. Naturally, the disclosures also have to be very, very precise, very clear. And perhaps if a person gets appointed repeatedly by one party as an arbitrator, then that can be a subject matter and one has to disclose every time. So therefore, not just the fact that you are associated with somebody as a law firm or something, because it happens repeatedly in some of the foreign jurisdictions that persons coming from the same law firm, they get appointed as arbitrators. So therefore, now the situation is that perhaps I think the disclosure matter has become very, very stringent. Yes.
Thank you, sir, for your valuable insight. I do agree that the fifth schedule has kind of put in place a lot of stringent practices which have to be followed. And we all know that the genesis of the fifth schedule comes from the IBA rules and especially the red, orange, and green list. So, Mr. Vasani, my question to you now is that the IBA very comprehensively laid out these situations which could, lead to justifiable doubts, which under the three lists. So, in your view, how do you think these requirements have been, when they've been introduced in the Indian Arbitration Act, do they conform to the international practice? What's your view on that?
Thank you, Ananya. When we go to court, we only hope and pray that we get a judge that is going to see things our way. When we go to arbitration, one of the beauties is we get to appoint an arbitrator that we think is going to see things in our way. What we can't do, though, is appoint an arbitrator that we know is going to see things in our way. And so what we're looking for in any arbitration is someone who is independent and someone who is impartial. To find some sort of common practice, in 2004, the IBA, the International Bar Association, put together a series of rules. They did so under a traffic light system of red, orange, and green. So the red list was those situations where it was impossible, the person was ineligible to take a position as an arbitrator. That was called red non-waivable. Then there was red waivable, which was a serious situation, and if disclosed, both the parties had to say, it's okay, we understand that situation, but we find it okay. That would be red waivable. Then there was orange, and orange was those situations where, depending on context, it could go to red, it could go to green, but it had to be disclosed, and then the parties and the arbitrator would discuss it and think about whether there would be a challenge. And then there were green, which were situations where they needn't be disclosed at all. So the key things about these traffic light system is that they were non-exhaustive. So there could be many other situations in which there were red situations, orange situations, and green situations. The problem, Ananya, before I get to the Indian context, is that these are what we call soft law. They're just guidance. They're just what common law and civil law practitioners got together in a room and decided these seem like pretty good situations to have in red, orange, and green. So let's say I was to start today an LCIA arbitration in London, and I was looking for guidance as to disclosure. I wouldn't find it in the LCIA rules. I would just find the justifiable doubts, which I think everyone agrees is a pretty good common universal standard. I would not find it in the English Arbitration Act, because there are not standards in there as to what are or are not justifiable. So if I was to make a challenge to an arbitrator in that situation, I would not have anything concrete within which to say, this should have been disclosed and it wasn't disclosed. The IBA rules would, as I said, would be soft law. So what they would tell me is, here are some guidelines which I can then refer to, and maybe they would be persuasive. But that's the limit of those IBA rules. So when I look at the Indian structure, I actually think it's very progressive in the sense that it codifies in legislation those same standards, and I understand I put them side by side, and I can see that there is pretty much almost a virtual overlap between the red situations and orange situations. And I think that that is a very progressive move, because it forces mandatory disclosure of clear issues in a way that in other jurisdictions you just don't have. So I would say that actually, in that sense, India is ahead of the game in its legislative approach, where in other places you continue to have the vague concept of justifiable doubts, which then lead to arguments as to what that means and whether that is or is not a situation. Because the IBA rules, as good as they are, as interesting as they are soft law and just the opinion of a bunch of lawyers in a room.
That's totally correct, and I hear you that the Indian system has kind of given a legal status to these lists, which is great. So, and as Mr. Lalit said, that the disclosures have to be very particular, have to be very they are very stringent. So, Dr. Gemawat, from a client's perspective, I mean, when you have an arbitration and when arbitrators give such detailed disclosures, how likely are you to direct your counsel that, if you see something is off, to kind of challenge the appointment of the arbitrator? Like, what are the things you look at when you take this decision?
Ananya, interesting question. And I think, normally, traditionally, we have not been bothered about all that disclosures. Particularly when I talk about the big corporates, normally there are people of repute or the retired judges, they have certain credentials and reputation. So normally we don't bother. But then this is not the case today. And the difficulty today, what we are having is, and I'm answering it in two folds. One is, from an industry standpoint, in a legal ecosystem, we don't have sufficient number of arbitrators and sufficient number of lawyers. So from a bar and bench standpoint, we are lacking people. So in a situation like this, what kind of people we are getting? The same set of people. Now, if you make the same set of people ineligible, or if you doubt that because of one or the other relationship, there would be justifiable doubts, of course there is. But the difficulty is, can we continue with this kind of arrangement, particularly in a legal ecosystem where we lack sufficient skill? But then having said so, today, and the list, as far as Schedule 5 is concerned, that list is illustrative in nature, in my view. It's not exhaustive. So relationship can be of any nature. But then if I don't put a question mark when the disclosure is made, then I would lose my opportunity of challenging that. So the only option which is available with me at that point of time is to scrutinize the list very carefully, and wherever we feel that there is any doubt in terms of impartiality or independence, there is no option but to challenge that. So this is how I'm looking at it. And anyway, I will answer some other topics.
Thank you, and I totally understand your point of view because, we see this on a daily basis because, the pool is a little limited and, we always end up appointing retired judges and the credential is so much you don't think there's any need to challenge really. So Smarika, my question is, as a counsel, in what situations would you recommend your client to challenge an arbitrator?
Thank you, Ananya. Under the Indian Arbitration Act, if anything that falls, if the disclosure falls under the 7th schedule, that's as a counsel for me is a no-go. I would definitely advise my client to go ahead and challenge it. Of course, you leave it to them to decide whether they want to waive this because the law provides for it. But the 7th schedule is something that is a no-go for counsels. Now, and as you just discussed, it's of course they all fall from or they cover parts of the waivable and the non-waivable red list under the IBA. Now, when we get into the larger 5th schedule, from, not the first 19, but so on and so forth, those challenges, we would actually go into the subject matter and then decide whether it's worth making that kind of challenge. Because as Mr. Gemawat or Dr. Gemawat also pointed out, the pool is so small. Do we need that kind of challenge? But at the same time, we must be aware that if you don't challenge it within the prescribed time limit, then it's done and dusted. So as a counsel, our advice is often to challenge it if it's under the 7th schedule. It's a no-go for us. And if it's on the broader scale, we definitely decide whether or not to challenge, because otherwise, the ship is sailed.
I just wanted to add something from the international context and to see if it's true in the Indian context. In the international context, we don't challenge unless we think we're going to succeed. Because if you challenge and fail, you're going to have a wounded arbitrator. And that wound you fear is coming back to you. So I wonder whether by preserving your challenge, you are potentially harming the arbitrator and potentially your view. So, and I appreciate that it depends on the credibility of your challenge, right? So even on the 5th schedule, you'd put something forward that has legs, right? So even if it fails, it doesn't fail because it was frivolous. But how does one go about in the Indian context of a challenge that fails?
I just want to make a comment here, and the difficulty here is the law provides a mechanism where the same arbitral tribunal would be deciding the fate of that challenge. Yes. Now, in a situation like this, parties would have a precarious situation whether to challenge or not, particularly if had it been a situation there where there are some business interests, etc., understandable, but then if there are retired judges, how can you challenge that? And because there would be one or the other reasons, your challenge is bound to fail. So now these are the difficulties which industry would face, and I think appropriate for me to comment here is that we do observe at times during the proceedings bias of the arbitrators, and it's very apparent. Can we do anything about it? Because there the proofs required are so difficult to prove all those things. Now, that is what the difficulty is. So the way in which I look at these provisions are that these provisions are meant to push the industry to go for an institutional arbitration. You will not face these difficulties the moment, because Schedule 5, Schedule 7, it's very harsh, I would say, very harsh. But the difficulty is, do we have option right now? So far as ad hoc arbitration is concerned, you will have to follow that process.
Mr. Vasani, there's one incident that I particularly want to point out, which is what I experienced last year, is we had an arbitrator, we nominated an arbitrator, and suddenly we get to know that he has retired and was a part of the law firm which was representing the opposite side. Now, we did not have objection to him being on the panel because, we know his credibility and, he's one of the best brains in the industry. But surprisingly, it was the opposite side that took the objection. Yes, said that, while he's retired, but there'll be some retirement benefit that he's deriving, and therefore he shouldn't continue. And you'll be surprised that ICC actually changed our nomination. So it's an incident where we didn't object. of any impartiality or independence, but we had an arbitrator change. So there is no straightforward answer to that then.
I think these are all questions which, I mean, we'll discuss a little more in detail now as the panel is going on. So let's delve a little deeper into it. So, Mr. Vasani, I have another question for you, is that what is the expectation from the arbitrators? You know, in your experience, are they expected to disclose all circumstances which give rise to justifiable doubts, or is it only those facts which they think would give rise to justifiable doubts?
So I think what we can all agree on is that justifiable doubt is the standard. There are probably three main ways one can determine the question of justifiable doubt, three sets of eyes. One is the eyes of the arbitrator, him or herself. That's one. Two is the eyes of the party. And three is the eyes of an objective observer. I think everyone agrees that the eyes of the arbitrator, him or herself, is not the standard, right? The subjective standard of the person who's being appointed is certainly not the standard of justifiable doubt. So we can put that one aside. The one where I think we don't get uniformity throughout different nations and standards is whether it's in the eyes of the party or an objective observer. For the reason that a justifiable doubt in the eyes of an objective observer may subjectively to that party, for whatever reason, may be okay. Or vice versa. What would be objectively okay to a reasonable third party, for that party, for some historical reason, may not be appropriate. So the way I like to think about it, and certainly the way I do my disclosure, is I do both. I layer what may be the objective standard, so what a reasonable third party looking at me thinking, has he disclosed something justifiable? But I also take any knowledge I may have of that particular party and I add that as an additional layer onto the objective standard, such that even if it's not justifiable to an objective person, I know that there is something about that party that they may have justifiable doubt. And I think this broader disclosure is starting to get traction, particularly in the United States. So I've had cases where, and some may find this leads to issues, and I think that this is a good segue into the next question, which is where literally I appointed someone who then gave a disclosure that he and I met at a conference 10 years ago, and we had a conversation, and maybe he watched a video that I was in, and all sorts of strange tangential relationships that I had with this person. And I thought to myself, it's out of hand. But at the same time, the idea is that they are just saying, this is me, this is everything I have. There can be no question because I've been absolutely transparent. I'm not making the decision of justifiable doubt or not. I'm just telling you everything.
Dr. Gemawat, your input on this?
Well, considering the scheme of the legislative framework, I think it is all the more important for arbitrators to disclose everything. Let's accept this reality that Schedule 5 is only illustrative in nature. Justifiable doubts, this independence, impartiality, these concepts are subjective in nature. The difficulty is, if you don't disclose and that is subsequently challenged, your award is bound to get set aside under 34. Now, that is the moment you say, if you disclose, then in that situation, it is difficult for you to say that it is partial or impartial. But then if you don't disclose and the award is against the counterparty, then there is bound to be an observation that there was, partiality and all that. Now, considering this framework, I think it's all the more important reasons, even for the clients, to consider that the arbitrators should be making all disclosures and there should not be any exception. Yeah.
I hear. And what I understand is, from hearing both of you, is that you both think that the arbitrators should give a full and complete disclosure. It's not a subjective disclosure, and it's a detailed disclosure. So My thoughts on this, and my question is to Justice Lalit, that do you think this is a double-edged sword? That detailed disclosures, does it encourage parties to challenge, to like make more challenges? And as Dr. Gemawat said, if you don't make the disclosure, then, and if something comes up, then also you're challenged. So how does one, what's your take on this?
See, this is my personal view, that what is expected of an arbitrator is far too stringent a requirement than what you expect of your judge. I'll give you two examples. I happened to be nominated as the presiding arbitrator at the instance of two nominated arbitrators. They chose me to be the presiding arbitrator. One of the parties was a joint venture entity which was promoted by a well-established company on the Indian company side, a multi-million company, and I happened to have 500 shares of that company. So I disclosed it, saying that yes, I do have certain shares, just 500, nothing substantial, nothing sort of, to be influencing the decision at any stage on the commercial side. But one of the parties, they just, sort of made it known to me that perhaps they would not like me to be the presiding arbitrator. So I stepped back, recused myself. So therefore, that's where the stringent requirement. If I was a judge and the very same company was before me as one of the parties, then perhaps going by the normal law, if you don't have anything substantial as a financial stake in one of the parties before you, you won't even bother to disclose that. Correct? So therefore, what is expected of arbitrators is far too stringent. Then the next. As a judge, I had an occasion to deal with a criminal matter where the managing director of a company was in a prayer seeking anticipatory bail. We granted him bail. Correct? Next time, the very same company came up on another issue. And now that very company is one of the parties in an arbitration before me. So I felt that I must disclose it as a fact, that look here, I've already taken a particular stand as a judge, nothing to do with the subject matter of the present dispute before the arbitral tribunal. But in the past, as a judge, I have taken this. Now the schedule doesn't speak of a role of a judge. Schedule speaks of role of an advocate. If you come from the same chambers, if you come from the same law firm, if as a lawyer you had advised, etc., etc. But I consider that the spirit of it, and as my learned one of the members said, it is not exhaustive, it is illustrative. So therefore, I took it as my responsibility to make it known to everybody. I, in fact, circulated the orders passed by me as a judge. This is the other extreme. So therefore, I think that having seen the stringency which emanates from this schedule, it is always better that whenever in doubt, please disclose. That's what I would consider it.
So, and if you don't mind me asking, did they actually challenge after you circulated the orders? Or?
No. That is what perhaps I think, to their credit, they also understood that these are completely different matters. And that's what I said. As a judge, if the very same matter had come up before me, there wouldn't have been any disability. I wouldn't be required even to disclose that. As a judge, you don't have choice in the matter. Whereas, as an arbitrator, you are actually chosen by the party. So therefore, that is why the requirements have to be tougher, have to be stringent. No doubt about it.
So I do hear you, and I mean, it is true that the job of an arbitrator is much more difficult than anybody else. So Smarika, what's your take on this?
I think let's all agree, at the outset, that disclosure per se doesn't make an arbitrator impartial or the arbitrator is not independent. Having said that, as Justice Lalit just said, that, his disclosure, in his case, his disclosure was based on his personal experience. So, and with the fifth schedule being illustrative in nature, I think it is important that one discloses to what one thinks may be an issue later on, because that the last thing you want is your award being set aside on the basis of any of the facts that's not been disclosed. And I genuinely feel that there's nothing as exhaustive or a more detailed disclosure or not so detailed disclosure, because here you have arbitrators who have been in this field for far too long. So they make good disclosures rather than let's term it as, good disclosures than calling them as, a detailed disclosure. I think that's the need of the hour, to make good disclosures and not, in Mr. Vasani's case, not make disclosures of, attending conferences together, and, those kind of things.
I hear you. So what I think is that there's a balance between, like a good disclosure and, well, it has to be detailed, but, it has to have a balance. But do you think that, as a party or as a council, when a disclosure comes, is there any situation in which a party or a council goes out and does some research on their own to kind of, just make sure that a good disclosure has been made, so as to say?
Ananya, honestly, everything is so available on the internet now. Yes, absolutely. You have access to all kinds of information. I mean, our LinkedIn profiles carry literally everything that we've done. So, wherever a party nominates an arbitrator, we definitely go back and look at their profile. We definitely do our research. It may not be that detailed, but I think all lawyers here do that. I mean, that's, I think, a given.
Dr. Gemawat, do you also believe in this practice?
I think that is one of the basic part of our profession, that we know the ecosystem. We know what kind of arbitrators we have. We know what kind of lawyers we have. So that's sufficient research. Not only the lawyers are doing, but then we as in-house counsels, we also do that kind of research. And some reality check, Ananya here. The difficulty which we face is that who would be challenging this? Particularly when on your panel there are retired judges. Now, that is the difficulty which we face. Other people we can always challenge, the lawyers are ready, but then normally the relationship between the lawyers and the bar and the bench is such that people don't have that daring of even challenging this. And it is, from a client standpoint, it is our difficulty to push the lawyers that no, it needs to be challenged. So I think that is what, and I think that awareness perhaps is required.
And Mr. Vasani, like internationally, like how?
Yeah, so there is technology now which allows you to, so you don't have to go searching individually in Google. You just put a name into a particular database and that technology will tell you everything that is already aggregated about a particular individual. The second thing I would say, and I think this is critical for lawyers, is actual knowledge and constructive knowledge. So if you know, so let's say the arbitrator didn't disclose something, but that information that wasn't disclosed is publicly available. So you didn't actually know because it wasn't disclosed, but the standard is not always actually, it's or could have known or should have known. So constructive knowledge, and then there's the question that if that information was in the public domain and you didn't make yourself aware of that fact, but could have simply by looking at it, has your challenge time expired because of that failure to look publicly at the information? So potentially there's a negligence lawsuit waiting if you don't actually do that exercise.
So, I mean, and I think we've all talked about the fifth schedule so much now, and it is very interesting, the situations which have been laid down there. And there are few of them which have, which are the most common ones which keep propping up. So something like repeat appointments. So, Dr. Gemawat, my question to you, as a client, are you more likely to challenge an arbitrator who has received more than 3 appointments in the past 3 years, or as you said, because you trust the credentials of the arbitrator so much that you wouldn't think that it's actually a...
Yeah, so I think interesting question. In a normal situation, and particularly where the big disputes are there, normally arbitrators are coming from, they have credentials, reputation, etc. So even if there are, appointments, it doesn't bother us. But then at times there are, different kinds of arbitrators. We have a mix of, the skill set. There, of course, it would raise my eyebrows undoubtedly that should I be checking it further. So it depends. It's very, very subjective, very, very subjective. But then, yes, as a client, we need to be very careful on that. And if suppose we have any doubt of any nature, then we certainly, raise those objections. But fact remains, as I said in my opening remarks also, we don't have sufficient numbers. The same set of people have been engaged by us also, and on multiple other occasions. So I think we need to be, objective in terms of our assessment. But having said so, we can't ignore this completely. We need to be careful whenever this proposal comes here.
And Justice Lalit, do you think that this should have been a criteria which should have been included in the 7th schedule so that, it would lessen the possibility of any kind of biasness?
See, according to me, a very delicate situation may arise. Supposing if an arbitrator gets nominated in the first matter by a party, and there is no association with that party, so therefore the disclosure is completely silent on the relationship with that party. And then the same arbitrator gets nominated in a second matter by the same party. You would disclose, so far as the second matter is concerned, about the fact that you are already an arbitrator in one matter. But would you disclose in the first matter that your repeated engagement in the second matter? Correct. And that's why one of the best cases which actually came up before UK Supreme Court, that Halliburton, correct, Lord Hodge, then the person concerned had disclosed everything, whatever he had. He had done some 3 arbitrations earlier, so therefore that was disclosed very fairly. But it so happened that the very same person later had got an engagement to be an arbitrator in 1 or 2 other matters, and that part was not disclosed in the first set of arbitrations. So therefore it's a very delicate balance, and that is why, according to me, we are asking for tremendous amount of stringent conditions and requirements from the arbitrator. Correct? As a judge, you won't even bother. Union of India or state appears before you on a number of occasions. You deal with those matters. Big corporations, municipalities keep appearing before you. The very same municipality may appear. So therefore, that is never taken as a disability for a judge. But for an arbitrator, it stands on a completely different footing because the party nominates, party selects, or party is actually sort of, the party autonomy comes in play. And since you are a private tribunal, so therefore all the more stringent or tough requirements. So therefore, at times it may happen that Halliburton is a very beautiful case to actually study on the point. So therefore, this is where it sort of, hits you. Yes.
So just taking a cue from what you said, and isn't disclosure supposed to be like a continuing obligation? So
it has to be. It has to be.
So the point about, if the arbitrator gets appointed on a second, then you disclose it in the first, then wouldn't you think that that is...
I may go a step further, because what normally under the ancestral model law, justifiable doubts, correct, about what? Is independence, impartiality. But the disclosure contemplated by Indian scenario under our Act also takes into account one more facet of the matter. That is to say that he shall be able to finish the matter within 12 months. Now, supposing in case he takes up an urgent assignment midway, should he or should he not disclose that? That's also a very delicate issue. So therefore, at times, the disclosure part or the requirements of disclosure can be multifaceted when it comes to our schedules and our requirements.
That's true, sir. And just from a counsel perspective, Mr. Vasani, Smarika, my question is that how do US counsels deal with repeat appointments from an international perspective, from a domestic perspective?
Yeah. So without any criticism of the Indian context, we have a bigger pool of arbitrators. We do appoint retired judges, but we also have barristers we appoint. We have professional arbitrators who are people who come out of law firms and decide they are just going to be arbitrators and nothing else. Law firm partners often have a busy arbitrator practice, and we have many non-lawyers who sit as arbitrators. So the concept of repeat appointments is actually less and less of an issue that I've seen in the international context over the years. That's not to say it doesn't happen, and of course the IBA has the 3 and 3, the 3 appointments in 3 years. But if you think about that, that's a pretty heavy standard to get 3 appointments in 3 years is a lot. I would say on your point of continuing disclosure, the 2014 amendments to the IBA rules had an obligation to disclose a new appointment by the same party or the same council. So that was actually added in 2014 to the rules to have an obligation to disclose. How does one deal with repeat appointments? I often find that repeat appointments, and you saw this in Halliburton, are very difficult to prove that because of repeat appointments, there is some sort of impartiality or independence issue, right? Because often it's the same council. How do you say, well, they keep appointing you, therefore they are a financial source of your appointments, and therefore you will, it's very convoluted. The party, again, it's a very difficult argument to make. There's not a direct, tangible conflict that you can point to, and it's somewhat amorphous. So I find it a difficult argument to make. So what I do is I do what's called a lock-in letter, which is it's not a challenge. It simply says that we take note of the fact that you have been appointed by this, and let's say they haven't disclosed 2 other appointments from the same council, which we have found. We have also noted from public records that you've been appointed in this case and this case by the same council. However, we accept the fact that you are independent and impartial, and we welcome you onto this arbitration. Now, what does that do? I'm not challenging you, but I'm telling the other 2 arbitrators, right, to have a look. And at the same time, I'm telling you, I'm watching you, right, as the arbitrator. So it's not challenging, and it's being very respectful, but at the same time, it's saying, I know, and now everyone knows, but welcome to the arbitration.
Everyone's watching you. Okay. Yeah, Smarika, do you have any input on this?
From Indian law perspective, this 3 years and 3 appointments, there is a reason why this has not been part of the 7th schedule, because I think even the legislature recognizes the limited pool that we have in India. And let me tell you, as councils, when we nominate arbitrators, of course, apart from this 3:3, it's based on the subject matter and their availability. And the limited pool that we have here is these are arbitrators who carry impeccable reputation. So there is a certain amount of respect, and you go with a certain degree of confidence that these people are independent and impartial. So hence, for me, again, this 3:3 rule is not such a big detriment, unless, of course, there is something jarring which comes out, but I don't see that as a big detriment.
So I think my takeaway from this discussion seems to be that while this repeat appointments is a situation under the 5th schedule, we don't really see it as something which really affects the doubts of the impartiality or independence of the arbitrator. So moving on, another, one of the situations which doesn't actually find place in the 5th schedule specifically, but it's of importance to all, budding arbitrators or aspiring arbitrators like us, is with relation to law firms. So, Dr. Gemawat, and my question to you, do you think that lawyers working in law firms have a more onerous requirement for disclosures? For example, if there's a large law firm and we've represented several companies, subsidiaries of those companies, would it be do you think that the lawyer has to disclose each and every subsidiary that they've worked on so as to complete this requirement? Do you think it's a more onerous requirement like that?
agree with that. Undoubtedly, for lawyers, particularly working in law firms, serving multiple clients, and they need to disclose everything. If they don't disclose, there is always an issue in terms of, challenging this later. We can very well say that, whether, it needs to be proved in terms of independence and impartiality, but then the fact remains that that is subject to that challenge. What I see is that from a legislative framework, we have given all that description. But, just compare it with a law firm which is doing advisory in transactions. They're the same firm, perhaps at times same partners, but then they keep two separate teams. They maintain that Chinese wall. That mechanism can also be provided in terms of when a disclosure is made. I think there should be some undertaking also that we would be maintaining Chinese wall even if we have, we are providing services to these clients, because at times it happens that the same party would be a client also. They have continuing relationship. I think that needs to be addressed because, that is the gap which I see. And the second gap which I see is that there is a change as far as the Arbitration Act is concerned, but then there is no corresponding change in the Code of Conduct for lawyers. I think the moment you do that, the Code of Conduct and the undertaking part, perhaps this issue might get addressed.
True. Justice Lalit, do you have anything to add to this?
See, it has been dealt with very beautifully and succinctly. I'll just give another dimension to it. See, A and B worked together as lawyers, both became judges of the High Court, and both are retired now, and they share the same office from which they operate. In matters where A becomes a nominee arbitrator, he along with somebody else chooses presiding arbitrator to be B. And when B along with somebody else becomes the nominee arbitrators in another arbitration, they choose A to be the presiding arbitrator. This is something, goes on for about, say, 6 to 7 instances. As a lawyer, the matter came before me. And my client wanted to challenge this to say that, sir, this is, to my mind, this is not something, a good practice. Now, the schedule doesn't say anything on this. Of course, the schedule came in 2015. When I was practicing, there was no such schedule. So the only thing was justifiable doubt. My advice to the client was, sorry, sir, please don't do that. And this is exactly what he said. Please don't rub the arbitrators the wrong way. Otherwise, you will have a wounded arbitrator. And that's something which you cannot possibly take that risk. So therefore, there are multiple kind of, possibilities. Perhaps all those possibilities are not dealt with and have been discussed in the schedule. Therefore, according to me and the learned speaker, it is true that this is only illustrative. So therefore, one has to see the spirit behind that. And the spirit behind that is, if there is anything which, as he rightly said, anything which a third party may entertain a justifiable doubt, then anything which comes in that realm, in that circuit, in that circle, or that compartment must be disclosed completely. So therefore, that's where we stand.
And we all come back to the thing that the job of an arbitrator is most difficult when it comes to disclosures. So, and in law firms, another issue which comes up very often, Smarika, my question to you is that law firm partners often hold executive positions in, arbitral institutions like the CAC, the ICC, or the MCIA. Do you think that should serve as a disqualification for other lawyers who work in the same law firm but don't hold, positions in the institution? In an institutional arbitration which is administered by these institutions.
I have one sitting right here. But, on a serious note, I don't think that should be a detriment. If I have a colleague partner sitting, let's say, on CAC board or an ICC board, does that mean that SAMCO as a firm cannot participate in any of the arbitrations that are under SIAC rules or under ICC rules, I think that's too onerous an ask. And I frankly feel that's literally stretching the idea of impartiality and independence to no good. Yeah, it's actually, yeah, to no logic. Yeah.
I agree with you, but honestly, this has actually happened to us not once but twice. So these are actually like people, I mean, litigants are taking, I mean, so as to say, advantage of fifth schedule in that sense.
We have a wounded arbitrator.
Okay. So now the next issue that we wanted to discuss, and Dr. Gemawat, we could have your view on this. Do you, before suggesting an arbitrator for your case, do you check whether your prospective arbitrator has taken any position in law on that issue, whether for or against? Is that a consideration that you have in mind when you're selecting an arbitrator?
Well, that is one small part of the process. But then the important thing for a client would always be that your arbitrator should have the subject matter knowledge. And they should have certain amount of business acumen. They should have certain amount of commercial understanding. And if they lack that, they would not be the right fit to decide the commercial matters. And I think that is what the industry faces the problem, that we don't have that kind of sufficient skill set. So this is one part. The second part is, yes, undoubtedly, at times, because of certain judgments of certain retired judges I'm talking about, then that gives us some certain amount of mindset of people, that what kind of mindset they would be having while they would be deciding the matter. And again, that gets linked with the commercial acumen, that gets linked with the business understanding. And I think that is what would matter. And I think as industry, as clients, we are careful on that, yeah.
And Justice Lalit, I know you mentioned earlier about, the case where you circulated the orders where you had passed, but is this an issue which, you're conscious of, or does it happen to you often when you sit as an arbitrator that you're influenced by any, position of law that you may have taken while you were a judge?
As one of the earlier speaker very beautifully put it, there are three pairs of eyes. One pair is that of the arbitrator, the second pair is of the party, and the third pair is a dispassionate third person. Whatever I may consider is not something which is going to impact or affect my impartiality and independence, is my perspective to the matter. I must actually put myself in the shoes of a third party and then consider whether is there anything which would lead to or give rise to justifiable doubt, and therefore see from the perspective of, from the pair of eyes of that third party. So therefore, rather than strain yourself, put everything before that third party, let him take that call. So therefore, that's why I always go by this idea, whenever in doubt, disclose everything, correct?
So you would have a string of orders to disclose every time then?
It's bound to happen. Now what else can I do? So therefore, it has to be.
Okay, so now, Mr. Vasani, just from the international context of it, lawyers in law firms often sit as arbitrators, as we have already discussed and you have said, and at the same time, colleagues have cases with similar issues. So just tying in these 2 points, do you think that this is a disqualification for an arbitrator, that the law firm has cases, pending on similar issues?
Yeah, so this is the double hatting issue. I just lauded the benefits internationally of law firm partners sitting as arbitrators, and one thing I see in the Indian context is that this is not a great phenomenon as you would have internationally. But there is the benefit in that of having a greater pool of arbitrators. The drawback is this concept of double hatting, where a law firm partner, or in fact anyone who is still acting as counsel, I do both arbitrator and counsel, where that person is sitting as arbitrator in matter A, and matter A deals with a particular issue, and is counsel in matter B, where a same or similar issue is in play, or that person's law firm is dealing with issue B. And where you have that situation, you are potentially in a situation where you could create jurisprudence as an arbitrator in matter A that you would then use to your benefit or for your law firm's benefit in matter B. There are now prohibitions being brought against this. Now, one could argue that as an arbitrator, you have confidential awards, so it's not really jurisprudential. There's no real precedent as a matter, so even if it came to the fore, it's not binding. Even in ISDS, it's not binding. It's still simply of persuasive value. But still, it is a practice that potentially could be very invidious. And at the same time, I think there is an understanding that double hatting is not something we should prohibit per se. Because I think it's very important that younger lawyers get the opportunity to sit as arbitrators. Because otherwise we are going to have a very limited pool, and we're going to have people who attend conferences like this, who have done LLMs abroad, who have practiced in fantastic law firms, who never get to sit as arbitrator. And then we would be missing out on a pool of arbitrators that are potentially fantastic at what they can do. So the best way to do this is to allow people to act as lawyers and as arbitrators, starting off in smaller matters, and to develop their skills. And I can tell you that I am a much better arbitrator because I have been a lawyer, and I am a far better lawyer because I've been an arbitrator. So having sat on both sides, I now know what to say, what not to say, because sitting on this side of the bench, I can see what I want to say and not.
Totally, I totally agree with you. And I know we're running out of time. Just one last small issue that I wanted to discuss. And Mr. Vasani, maybe we can start with you only. What kind of, and this is an issue which does not find place in the fifth schedule at all, is what kind of personal relationships should be disclosed by a prospective arbitrator?
Yeah, so I think one has to be careful here because sometimes professional and personal blur. You can have friends in the industry. I think certainly, I can tell you, I never appoint an arbitrator I don't personally know, right? So that's just, it's very open. That's the whole point of having arbitration. Now, that doesn't, as I said, that doesn't mean that person is going to rule in my favor, but I know them, I know they will listen to what I have to say. I think I know how they think. I've looked at their prior awards, et cetera, et cetera. But certainly, look, family, right, is an obvious clear one. Although I thought about that in the Indian context where everyone is uncle and everyone is bhai, right? So in fact, that would be far too big. But certainly, family. We have romantic, present and past, which is sometimes difficult if the past romantic was illicit or something no one wants to bring up. I think friendship beyond professional. So where it's not just let's grab a coffee at the periphery of the conference, but let's get our kids together for a play date and hang out with our spouses on a regular basis. The most interesting one, which I find fascinating, and I don't know if it's ever come out, but it will, is enmity. So actually it's the opposite of personal relationship, where you hate each other, right? Now, in a long career, I can think of maybe two people that one was this is an interesting one. One was an arbitrator I challenged. It wasn't a great challenge, I accept, looking back. But at the time, the client needed it. It was successful, but he did not take it well. And he resigned, but he resigned with a lot of vitriol. And that would be, to this day, not happy with me for making the challenge. Another is a lawyer in a very contentious case where it became quite aggressively personal, unfortunately, but sometimes these things happen, who I can imagine sitting as arbitrator with me, I would challenge for enmity. But that is a very interesting one. And who would admit that I think you hate me so much that you are not going to rule independently or impartially on the case? So that one for me is a fascinating potential topic for challenge.
That would be really interesting to see how that challenge plays out, though. Justice Lalit, I mean, my question is to you now. I mean, do you think it is correct for an arbitrator and a lawyer who's appearing before that arbitrator to interact during social events? And where should one draw the line? Because the friendship and the relationship between the bench and the bar is quite prominent. So where should one draw the line?
See, famous Chief Justice, former Chief Justice of the Supreme Court once said, as a judge, don't lose your friends who are already your friends. But as a judge, don't make new friends. So therefore, that's where it applies when people come from the same bar, same stock. And that's how it must be. Now, I'll tell you, there are certain lawyers that my friendship with them goes beyond just having a cup of coffee. So therefore, we perhaps I think go together, go to certain vacations together. So when I became judge, I followed this logic or this principle that they won't appear before me. So it was something like, conversation between me and those set of lawyers to say, do you want me as your friend or do you want me as your judge? Choose. And they chose the friend in me. So therefore, they refused to appear before me. Now, whether same logic will apply when I become the arbitrator. So therefore, that is exactly why I say that the logic or the parameters or the requirements which are there when you are a judge and a lawyer, same logic or same requirements must apply when you are an arbitrator and a lawyer appearing before you. So therefore, that's where it stands. But over a period of time, you make friends with somebody and you like that particular, the person. So therefore, there is a possibility that perhaps you may develop friendship which may go beyond just having a cup of coffee together. Then perhaps I think the call has to be taken by either of them, not to appear before the arbitral tribunal, and the arbitrator not to take up the matter which is initiated by that particular lawyer. So it applies both ways. Yes.
Thank you so much. I think we've run over time, so I just want to thank all the panelists for their very insightful thoughts. I think it was a very interesting session. I hope you all enjoyed it, and I hope everyone enjoyed it. So thank you so much. Does anyone in the audience have any questions? I'm so sorry. Okay, sorry.
The 12-month rule actually suggests availability of the arbitrator and his ability to manage his calendar. As part of the disclosure, should he be saying that I'm already an arbitrator sitting in 3 arbitrations and I won't be able to accept another appointment? Or if he is overconfident, should he actually still disclose that he is sitting in 3 arbitrations already?
See, that is exactly why it depends upon his subjective sort of an analysis. Take, for instance, it's the very first assignment. So there is no difficulty. He can as well finish in 12 months. Now, repeatedly, there are second, third, fourth, 4 or more assignments. What should he disclose when the 5th assignment comes in? So therefore, he must naturally disclose all 4 earlier. But should he not disclose in the first assignment that, look here, you reposed confidence in me saying that I don't have enough number of arbitrations before me, so therefore I'll be able to dispose of all the matters. But now that I am saddled with 4 more arbitrations, what is the scenario? So therefore, I'm putting this, why? Because the disclosure according to Indian standards is that you must also be able to finish the matter conclude the proceedings within 12 months. So therefore, the disclosure has a different significance, not just your interest in the person concerned or in the property, but something beyond that. So therefore, it's a continuing obligation so far as to disclose all these material facts. So theoretically, the arbitrator must disclose, but practically, I don't think that perhaps this attitude or idea is followed to the hilt. Yes.
Can I ask my question? Yeah, so there was as a solution to the consequences of a wounded challenge, a wounded arbitrator, one of the solution that was mentioned by the panel, I don't remember who, was institutional arbitration. When the challenge was to an ad hoc arbitrator or an ad hoc tribunal. But then again, institutions have their own way of dissuading challenges. Like, I don't know what the figure is now, but some time ago, SIAC, just challenging the tribunal, you had to pay $8,000. So that's, again, not a good thing. So what do you have to say about this? And second question is, I repeatedly heard this expression, limited pool. My question is, where are you getting this information from? I mean, I know literally hundreds of trained, qualified, smart people desperate for an appointment. How do you say there is a limited pool in India?
The last question was the limited pool. The fact remains that if you notice, of course, this data is not available in public domain in terms of how many arbitrations are going on because it's all, private records. But
This is the second question you're answering?
Yeah, second question I'm answering. But the fact remains that in industry, most of the people, most of the lawyers, most of the in-house counsels or GCs, they are aware that who all are available as arbitrators, who all are available as lawyers. So the fact remains, and it's a reality, that we don't have sufficient number of arbitrators. When I talk about arbitrators, I'm right now talking about retired judges only, because the tradition has been, we can very well say that...
No, then you're limiting your pool voluntarily.
Yeah, exactly, because you are limiting your pool for the simple reason that this is what the trend is. As regards your first question is concerned, you will have to remind me again, because that was targeted towards whom I am not too sure.
I can answer the first one on institutional. So where the institutional arbitration has the court or the board who decide the challenge as opposed to the tribunal. If it's the tribunal that decides, it's the same whether it's ad hoc or institutional. There's no difference. The difference is where the court decides the challenge or a board decides a challenge and not the tribunal. In those instances, I have found in my experience two diametrically opposed factors. One is at the beginning of a case, so before the case has started, the ICC court, for example, or the board is very keen to avoid conflict of interest. So even the slightest potential conflict, they say, let's just move this arbitrator. So let me give you an example. 2 weeks ago, the LCA court appointed me to a matter as sole arbitrator. I disclosed, and I didn't have to disclose, but I disclosed that I had been appointed by one of the law firms on the claimant side 5 years ago, right? But the matter was ongoing. And I disclosed that. I said, but it doesn't affect my independence or impartiality, and it's 5 years ago, it's not 3 and 3. And the LCA court decided not to move ahead with my appointment. Right now, I have no issue with that, because they want to avoid even the slightest hint or perception of conflict. So I find institutions at the beginning of the case very keen to avoid any conflict. Once the case has started, and then a challenge comes in the middle of the case, institutions are very keen to avoid anything except really meritorious challenges, because they don't want to derail the arbitration process. And I find challenges that I think actually, on balance, should have been accepted, were not accepted by the court, but of course by the ICC court, the LCA court, but of course you then have the final court, the national court, to have a set-aside issue. But I think the interesting part of that is you have the institution which acts as a balance or an anchor on the question of the challenge.
I'm Santosh Pandey from Sarthak Advocates and Solicitors. And the question is to Justice Lalit. Does the arbitrator's disclosure have to be as exhaustive as to include the publicly available details? Or is it that a party is supposed to do a due diligence over and above the disclosures made?
See, whatever the party may choose to do by way of certain research or analysis is for the party to do that. What the law obliges the arbitrator to make the disclosure, and certain items have been put in the concerned schedules. So therefore, his disclosure must deal with every single facet of that. And when he says that I don't have any interest or in the property or in the persons concerned, that must be true and faithful disclosure. He should not depend upon the party to find out real facts or real circumstances behind that. So the arbitrator's obligation is to make the full disclosure.
Thank you so much. I think we can take the balance questions during lunch, maybe. Okay, thank you, everybody. Thank you.